it's Kim. So this is a 2019 document. This is actually against Jeffrey Epstein, but let's see. It says it's a hearing for the Epstein dismissal. I saw Maureen Comey's name in there, and then this Jeffrey Berman, seen that name. Anyway, just saying, I've seen the names before, but let's just go on here. That other document is like 2,000 pages, the one that I just did. Ooh, so I'm trying not to get too bogged down in this one. This one's only like 86, so this is much more manageable. But anyway, this is the United States District Court, Southern District of New York, United States of America versus Jeffrey Epstein, the defendant. This was New York, New York, August 27, 2019. So he may have already passed at this point. I can't remember when he died. Was it the 10th? Hold on. I want to look at that. Oh, yeah. When did he die? Uh, Sorry. Yeah, August 10th, 2019. So this is a case to dismiss all charges, I guess, against him since he's not there. So before Honorable Richard M. Berman, District Judge, appearances Jeffrey S. Berman, um, the United States Attorney for the Southern District of New York by Maureen R. Comey, Allison Moe, Assistant United States Attorneys. She's been since fired. That's a good thing, Maureen Comey. And then Martin G. Weinberg, PC, Attorney for Defendant. And then Martin G. Weinberg. And then Steptoe and Johnson, LLP, Attorneys for Defendant. Reed Weingarten, and Michael Miller, Southern District of New York. Yes, Southern District Reporters, PC. Okay, so case called, the court. Good morning, everyone. Please be seated. So just some housekeeping. We have a podium here for both attorneys and others who may be speaking. And so we would like you, attorneys and others who are speaking, to come up to the podium. This room is a little cavernous. Without the podium over there, we'll be more comfortable. For starters, and for this, you don't have to go up to the podium. If you could just indicate your names. This table in front, to my left, your right, are defense counsel, and that table to my right, your left, are government attorneys. If we could just ask the attorneys to introduce themselves. So, Miss Comey, good morning, Your Honor. Maureen Comey, they misspelled her name there, or up at the top. And Allison Moe for the government. Joining us at the counsel table are Special Agent Amanda Young of the FBI, Detective Paul Byrne of the NYPD, Mr. Weingarten. Good morning, Your Honor. Reed Weingarten. Mr. Weinberg, Martin Weinberg. Good morning, Your Honor. And the court, good morning. Mr. Miller, good morning, Your Honor. Michael Miller from Steptoe and Johnson on behalf of the defendant, and then the court, great. Again, good morning to all of you. This hearing that we're having today considers the government's motion to dismiss the indictment in this case. I must add that it also serves as the opportunity for me to thank all of you, the attorneys and the victims who are here today, among others, for your very hard work and dedication in this case. We also have here today the U.S. Attorney for the Southern District of New York, Jeffrey Berman, who has also been very helpful and indispensable in this matter. The news on August 10, 2019, that Jeffrey Epstein had been found dead in his cell at the Metropolitan Correctional Center at the MCC was certainly shocking. Most of you, and myself for that matter, were anticipating that the next steps in this case would be defense motion practice, including a motion to dismiss, followed by a trial on the merits before a jury if the motions were not successful, and through which the accusers and the accused would come face to face, allowing everyone to get their way or their day in court. Mr. Epstein's death obviously means that a trial in which he is a defendant cannot take place. It is a rather stunning turn of events. The government's motion to dismiss the indictment because of Jeffrey Epstein's death on August 10, 2019 is relatively straightforward. In my opinion, a public hearing clearly is nevertheless the preferred vehicle for its resolution. Incidentally, while I'm on this subject, I got some help today from the New York Law Journal from two professors who write that a hearing is, let me tell you exactly what they said. They say, in part, that this is an odd moment for transparency in a criminal case. I think that this is an odd sentence to hear about transparency in a criminal case. They go on to say that normally, if a prosecutor seeks to dismiss an indictment for such a obviously worthy reason, the court would simply grant the request. As to that statement, I respectfully say it is incorrect as a matter of law. They go on to say the judge would not schedule a hearing and he definitely would not allow the victims to speak. If he did hold a hearing, whatever informational interests the victims may have would be served by affording them a chance to attend the hearing, not by giving them a speaking role. I read it. It was incredulous. I'm still incredulous. I don't quite understand at all. There is a suggestion in the article that the reason they are making these suggestions has to do with the minimization of drama in this case. In the Jeffrey Epstein case, there has not been much minimization of drama, and what little drama might happen today, I don't think it would be very significant. On a somewhat more serious note, don't quote me on this, but it is my understanding that one of the authors of that article is himself counsel in one of the Epstein related cases. I was surprised to learn that very recently. I'm certain it is true. I was also surprised that aspect was not disclosed in the law journal. But in any event, I think you know where I'm heading. I respectfully disagree with the law journal piece. I was saying that the government's motion is relatively straightforward, and in my opinion, a public hearing is clearly, nevertheless, the preferred vehicle for its resolution. Yes, resolution. I'm still convinced of that. A few may differ on this, but public hearings are exactly what judges do. Hearings promote transparency and they provide the court with insights and information which the court may not otherwise be aware of. The victims have been included in the proceeding today, both because of their relevant experiences and because they should always be involved before rather than after the fact. Indictment 19 CR 490 charges Jeffrey Epstein with sex trafficking and with conspiracy to commit sex trafficking. The U.S. Attorney on August 19, 2019, requested that the court approve the government's proposal order of whatever prosecutor. I don't know how you say that. I think that's a rough justice. That means noli prosecute, whatever, discontinuance by the prosecutor of all or parts of the case that he or she has commenced. The government, in its motion, concludes that Epstein's death abates these proceedings. In accordance with Federal Rule of Criminal Procedure 57B, I determined to hold a public hearing and I notify the victims that they will be given the opportunity to be heard before any final action on the motion. That is the purpose also of today's proceeding. I would do that every time. Also recognize that Mr. Epstein, also recognize that Mr. Epstein died before any judgment of conviction against him had been obtained and that the government's proposed orders appears in form and in substance to be appropriate. Federal Rule of Criminal Procedure 48A codifies the noli prosecute, process. It is entitled dismissal, and it states in relevant part that the government may, with leave of the court, dismiss an indictment, information, or complaint, and that leave of the court proviso, you should know, was added as an amendment to the original draft of Rule 48, which had originally provided for automatic dismissal upon the motion of the government. This proviso, in my judgment, is clearly directed toward an independent judicial assessment of the public interest in dismissing the indictment. Thus, even whereas in this case the standard of court review is differential, the court must still make its own independent determination. A conclusory statement from the government that dismissal is appropriate does not satisfy the court's obligations. It is also, in my view, required that the court consider the views of the victims in the case at the hearing. and before deciding whether to grant the motion. This is being done here both as a matter of law and as a matter of respect that we have for the victim's difficult decisions to come forward in this matter. In a case called United States versus Heaton, Heaton, the government filed a Rule 48 motion for leave to dismiss a charge against a defendant who allegedly committed a sexual offense against a young victim. Although I should point out very importantly that that defendant was still alive, which distinguishes it from our case. Nevertheless, I think it is relevant because in evaluating the Rule 48 motion, then District Judge Paul G. Castle, who is now a law professor at the University of Utah and is regarded to be a noted expert in crimes rights or victims' rights, concluded that under the Crime Victims' Rights Act, victims have broad rights that extend to a court's decision whether to grant a government motion to dismiss under Rule 48. I completely share that viewpoint in these circumstances, even though the facts of our case, as I said, are somewhat different from those in Heaton. I believe it is the court's responsibility and manifestly within its purview to ensure that the victims in this case are treated fairly and with dignity. The fundamental substantive principle which applies in considering the government's motion is termed the rule of abatement. This principle originated in the English common law. It was adopted by most U.S. federal courts, but more recently it has faced some appropriate criticism. The rule of abatement is best explained in the Second Circuit case of U.S. versus Wright. In that Wright case, two defendants had pled guilty to embezzlement and tax evasion. Both defendants appealed, but one of the defendants died while his appeal was pending in the second court. The Court of Appeals ruled that under the rule of abatement, the judgment of conviction against the deceased defendant was required to be vacated and the indictment was to be dismissed. The Wright court held that when a convicted defendant dies while his direct appeal as of right is pending, his death abates not only the appeal but also proceedings had during the course of the prosecution. The Second Circuit, incidentally, has also held that when a criminal conviction abates upon the death of a defendant, any restitution ordered as a result of that conviction must also abate, and it is also ruled the same with respect to associated forfeiture orders. This latter application of the rule of abatement regarding forfeiture has not been universally accepted among federal courts, but it certainly is the law in this circuit. Some of you may be interested to know that some United States courts, state courts, have criticized the rule of abatement, particularly in the face of growing recognition of victims' rights in the criminal justice system, including the Crime Victims' Rights Act. It has been written and contended in the Brooklyn Law Review. I can give you the site later, that when courts abate criminal convictions, they reimpose a burden on victims that legislatures intended to alleviate through these victims' rights statutes. The state Supreme Court has even concluded that the expansion and codification of victims' rights provides the changed conditions needed for overruling the rule of abatement. It has also been stated that Alaska statute and its constitution now require the criminal justice system to accommodate the rights of crime victims. Further, that the abatement of criminal convictions has important implications for these rights. But coming back to our case, which is what you're concerned about, and I am as well, it is appropriate to conclude that if the rule of abatement applies to a convicted defendant, as in the Wright case, it should also apply a fortiori, whatever, in the Epstein case, which was still in the pretrial phase when Mr. Epstein died, when there had been no conviction. Hold on. So that's just some background I wanted to share with you. At this point in time, I would like to turn to the government prosecutors to hear from them in support of their Rule 48 application to dismiss the Epstein indictment. Ms. Comey, thank you, Your Honor. Would you like me to address the court from the podium? The court, if you wouldn't mind. Ms. Comey, thank you, Your Honor. I believe Your Honor has accurately summarized the state of the law as set forth in our papers in light of the clear second court law that upon the death of a defendant, before a final entry of judgment of conviction, all proceedings must be abated. In light of that clear law, the government is legally obligated to seek dismissal of the pending indictment against Jeffrey Epstein, and we respectfully submit, likewise, that the entry of the proposed order is similarly required by law. A few notes to make about that, though, Your Honor. To be very clear, dismissal of this indictment as to Jeffrey Epstein in no way prohibits or inhibits the government's ongoing investigation into other potential co-conspirators, nor does it prevent the bringing of a new case in the future or the prosecution of the defendants. It also does not, it also does nothing to prevent the government from continuing to explore the possibility of seeking civil forfeiture of any assets that were used to facilitate the crimes charged in this indictment. Indeed, as has been stated publicly, investigations into those matters have been ongoing, remain ongoing, and will continue following dismissal of the indictment here. I would also like to note that, as the government has previously mentioned, this dismissal in no way lessens the government's resolve to stand up for the victims in this case, both those who have come forward and those who have yet to do so. We agree with Your Honor's sentiment that those victims should be respected, and we appreciate Your Honor's recognition of that. One housekeeping matter that I did want to reference for Your Honor. The protective order in this case requires destruction or return of any and all discovery material upon conclusion of the case. We have been in communication with defense counsel who have confirmed that they have returned all physical copies that they have of discovery that the government has produced to date, and they are in the process of deleting any copies that they may have made. So the parties are in compliance with the protective order. Finally, I just wanted to say a word about the victims in this case, and particularly those who are here in court today. I'll note that in light of the court's order indicating that the victims and their counsel will be permitted to be heard in court today or here today, the government has endeavored to provide notice to all known victims of today's proceedings. We did so either directly, where the victim was not represented by counsel, or through counsel, where the victim is represented by an attorney. The government does not know exactly how many victims or their attorneys are here today, and we do not know how many of them or their counsel would like to speak. To the extent any individuals do wish to speak, we do not know the substance of what they would like to say. We have left that entirely up to the individual decisions of the victims and their attorneys. I will note, though, that throughout this case, the government has endeavored and done our utmost to fulfill our obligations under the Crime Victims' Rights Act. We have done so by trying to keep as many victims as we are aware of up to date about the ongoing case and about any developments in the case. We will continue to provide services and offer services to any of the victims in this case, even after the indictment is dismissed. Both the U.S. Attorney's Office and the FBI have been in touch with all known victims, or have attempted to be in touch with all known victims, either again directly where victims are not represented by counsel, or through counsel where they have attorneys. We have expressed to them that services are available for those who wish to take advantage of them. Unless the court has any questions for me, the government will otherwise rest on its papers. The court, I just have one question. The protective order, is that self-executing, or do I need to do something? Ms. Comey, it is self-executing, Your Honor. The court, thanks very much, Ms. Comey. Ms. Comey, thank you, Your Honor. The court, yes. I'll turn to counsel for the defense at this time. Mr. Weingarten, I'm happy to hear from you. Mr. Weingarten, thank you. Your Honor, I think it is An understatement of the year to say the world looks and feels differently today than it did the last time I was before you. For us, the elephant in the room is what happened to our client. I would like to tell you how we see the world and where we are on that subject. We start with the Attorney General's statements, public statements, that there were very serious improprieties in the jail. We obviously read the press. We see that the warden has been taken out. We see that the guards on duty at that time have been put on leave. We understand guards are refusing to cooperate with the investigation. We've heard allegations that people at the time who had responsibility for protecting our client falsified information. We understand that there were orders out there that Jeffrey Epstein was never to be left alone and that the orders were ignored by many of the employees of the prison. In a word, yikes. In addition, obviously, we followed the medical examiner's report, or we haven't followed the report. We haven't seen it, but heard conclusions. Initially, not enough evidence to come to a conclusion. Wanted to see more. We assumed she was talking about the videotapes, but then came to the conclusion that it was suicide. We report to the court, suicide by hanging. Mr. Weingarten, yes. The court, was her conclusion? Mr. Weingarten, yes. And we report to the court that we had a doctor there at that time, and we also have been in receipt of a tremendous amount of medical and scientific evidence volunteered to us, opining that the injuries suffered as reported were far more consistent with assault than with suicide. And we're happy to supply the court with all the information that we have. Now, in addition, as the court noted, we were underway with our pretrial motions, and the court obviously understands the NPA, or the non-prosecution agreement, and the role of the NPA was going to be critically important. And I would simply like to report that we went pretty far along. We interviewed all of the relevant lawyers on the defense side who participated in the NPA, and we were satisfied that we had a very strong argument that every one of those lawyers believed, with an objective basis, that the deal was global. That is, at the time, the court, I'm sorry that Mr. Weingarten, the deal of the NPA was global. That is, more specifically, at the time, the Florida prosecutors and agents knew of conduct in New York, and that no competent defense counsel negotiating in good faith with the prosecutors would have ever agreed to deal back then, or to a deal back then, that allowed non-New York prosecutors to indict for precisely the same conduct in the future, which of course is what happened. In addition, we have come up with very powerful evidence. We believe that Florida prosecutors who participated in the deal steered the victims and the alleged victims to New York on more than one occasion because they did not want to suffer the slights of attacks against them. So we've advanced the ball on this very subject, and we're prepared to completely report to the court as to where we are and what we've done. Another point, we obviously had contact with our client at or around the time of his death, and obviously the attorney-client privilege survives death, and we're not going to forfeit that privilege, but we will report to the court with as much specificity as the court may want that at or around the time of his death, we did not see a despairing, despondent, suicidal person, and details to follow if the court wishes. The 800-pound gorilla for us, of course, are the video surveillance tapes. Obviously, we assume there's a tape that leads directly to the door where Jeffrey Epstein was housed. If that tape reports for 12 hours before his death that no one went in or out of that room, then the suggestion that there are something other than a suicide seems preposterous. But there is no evidence that has surfaced to date, just the opposite. We've heard and we actually read in the press that the tapes were either corrupted or not functioning. Talk about a yikes. If in fact the system was broken for 6 months before Jeffrey Epstein was housed, I mean, that would be stunning incompetence. If it was allowed to continue to be inoperative when Jeffrey Epstein was housed, it would be incompetence times 10. But what if the tapes only broke down or were inoperative or were corrupted on the day he was killed or the day he died? Then we're in a completely different situation. So, where does this lead? I think where it leads, Judge, is there are incredibly important questions that remain open. The public interest in this matter is obvious from this courtroom. There are conspiracy theories galore, and we are all for finding the truth. We believe this court has an indispensable role to play. Whether or not this indictment is dismissed, I think this court has the inherent authority to find out what happened on his watch or its watch. Obviously, when the court detained Jeffrey Epstein, the court did not anticipate that weeks later he would be dead in his cell. I think, given the inherent authority of the court should make inquiry. This could come in many forms. Obviously, the court made inquiry as to what happened in the first incident. When there was an allegation of an attempted suicide, the court made inquiry. The court obviously was interested. I recall your language. You talked about that being one of the several open questions indicating an interest on the court for the others as well. Obviously, the ultimate question is what happened to the client. The court. You're talking about the July 23rd, 2019 incident, Mr. Weingarten? Yes. The court obviously could hear or could hold hearings. The court could assign a lawyer to help the court. I think this is an area where there is an intense public interest. We have complete confidence in the prosecutors in the Southern District and the FBI to do a competent investigation. But these are allegations against serious components of the United States Department of Justice. Sometimes the appearance of justice is just as important as justice itself. I think the court supervising or at least keeping an interest in this proceeding is incredibly important for the public to have confidence in the ultimate hearings and certainly for us to have confidence in the ultimate findings. Oh, sorry, I said hearings. Ultimate findings is what should have been. Okay, one more issue, Judge. The conditions of the jail, in a word, they were dreadful. Not just for Jeffrey Epstein, but for many of the prisoners over there. This is a prison within the shadows of this courthouse. The situation is rife with vermin. The abuse and the conditions in that prison, in a word, are a disgrace, and everybody knows it. A person with authority told us, someone with knowledge, that the prisoners in Guantanamo, and he spoke with personal knowledge, are treated better than the prisoners right across the way. The feds certainly know how to run a disciplined, clean prison. I've been in 20 of them. They know how to do it just fine. And the question is, why in the world does it not happen down the road? I think that is a perfectly legitimate subject for the court to make inquiry. In a word, we want the court to help us find out what happened. The court has a role to play. It is the institution that most people have confidence in these very troubled times. So whether or not you dismiss the indictment to us is beside the point. We want to stay on the case. We want, we want you to conduct an investigation, and we want to know what happened here. Thank you, Your Honor. So I'm going to stop here, and then we'll start back up at the court right here. But anyway, it's just kind of interesting. They're pushing for the investigation of Epstein's death, even though they're dismissing the case. Anyway, talk to y'all later. Bye.